The feeling, Mr. Speaker, that the banking amendment bill dealt with, Mr. Speaker, which I did not go into much detail, Mr. Speaker. It deals with things like the limitations of a licensed financial institution to for including the maintenance of specified assets, Section 55, Mr. Speaker, 57. The definition that was positioned under the provision for the maintenance of specified assets is repositioned in the Act as a new provision that provides a definition of specified assets. The new provision is Section 43A, Mr. Speaker, includes as specified assets notes and coins which are legal tender in the currency union and foreign notes and coins that the central bank may specify. Balances at the central bank and net balances at a licensed financial institution in the currency union, but while the balances are negative, they'll be subtracted from the specified assets, Mr. Speaker. Mr. Speaker, all the islands in ECCU, they maintain an account in the central bank. So that law says if you are in overdraft, it's subtracted. So you only show the net balance, Mr. Speaker. And I'm very pleased to tell you, Mr. Speaker, that St. Lucia always stays within its quota. There also provision for minimum paid up or signed capital, Section 44. Section 44 is amended in the bill to change references to St. Lucia to the currency union and to insert a new provision that requires the central bank to approve the holding of assigned capital in the form of specified assets, Mr. Speaker. The bill also amends the provision in the Act on maintenance of the reserve fund, Section 45, for a licensed financial institution or licensed holding company to obtain the written approval of the central bank if a declaration, credit payment, or dividend or other transfer from profits results in an impairment of the capital required under the Act, inadequate and inappropriate forms of liquidity, or negative return earnings or accumulated deficit. Again, Mr. Speaker, in an endeavor to protect the depositors, Mr. Speaker. Mr. Speaker, the bill amends the Act to remove references to capital base and substitute Tier 1 capital in the provisions in the Act relating to exposure, Section 49, restrictions on exposure-related parties, Section 50, and the prohibition of engaging or investing in trade and outsourcing, Section 53. Submission of returns and production information as required by the central bank, Section 89. Changes are made in the Act, in the bill, to the provisions on the restrictions on lending to employees, Section 51. Acquisition and establishment of financial subsidiaries, Section 54. Restrictions on investment in real property, Section 55. And there are other provisions, Mr. Speaker, on the appointment of external auditors, which I dealt with, Mr. Speaker, before. There is amendments are made in the Act under the bill. For example, the provision in the Act that relates to the disclosure for the basis for charges, which the member for Suez spoke about. Section 92 is modified to state that a financial institution must make such disclosures to the central bank. It must say to the central bank on what basis they are charging, Mr. Speaker. Like when we have to give our statements to the Integrity Commission, they charge us money. Or if you want a statement from the bank, they charge you money. So in the new Act says, you have to say why you're charging, what's the basis of the charge, Mr. Speaker. And must make disclosures to the central bank, Mr. Alterations are also made in the bill to the provision in the Act that provide for the minimum criteria for determining whether a person is fit and proper, Section 97, and the disqualification of a director officer, Section 103. Capital increase to existing shareholders, Section 131, and termination of the office of administration, Mr. Speaker, Section 127. Grounds for receivership, Section 148. Commencement notice of receivership, Section 140. Avoidance of pre-receivership, Section 147. Report, publication, and disposal of abandoned property, Section 168. Secrecy of information, Section 178. And administrative policies to replace the credit of the central bank, section 180, and repeal and savings, section 192. All these are basically adjustments, Mr. Speaker, to these sections to make them more effective and give them more clarity, Mr. Speaker. Also, Mr. Speaker, there's a new provision to make provision for receivership and compulsory liquidation in respect of a person under section 1381B. There's a new section 138A, Mr. Speaker. And the schedule, Mr. Speaker, the Schedule 1 lists the fees for licensed financial institutions, also subsidiary in the bill, as well as Schedule 3 that considers the offences of which liability to conviction may be discharged by payment of a fixed penalty, Mr. Speaker. So, Mr. Speaker, this bill really seeks to give clarity, and it seeks to deal with a resolution to an improved framework, Mr. Speaker, for the operation of banking in St. Lucia, Mr. Speaker. I thank you, Mr. Speaker.